have to do something with the Logan mark. Do you not have a copy? Case.
Let me share.
You know what? I don't need it. But before I do that, let's assign the roles for Thursday for Sissy Harrison, because we had the speakers on last Thursday. We didn't get to have you guys choose, or I choose for you. So we're gonna need at least 9 people, and then some people could double up if
Is the list of the roles within here, or?
yes, the list of the roles, which I will call out loud right now. Who are we missing? Jonathan's not gonna be here, he had work, and I think everybody else is here. Oh, and the other Amanda, okay. So normally we're 1, 2, 3,
What, I think 12.
11. No, yes, 11. So what we do is probably have 2 attorneys for DCF and 2 attorneys for Sissy. So I need, for witnesses, Sissy Harrison herself. Anybody have an inclination?
Wait, what,
To be-
the mother?
Yeah, the young girl, the mother of the 2 twin girls, Jennifer. Okay, then Christine Pashas, the court-appointed investigator and the author of this report, Nicole. Then, so there's 2 DCF workers. One that worked with the whole Harrison family, including Sissy when she was younger, and then one assigned to Sissy when she becomes pregnant. Anybody have
So,
inclinations, Amanda?
Maybe me and the other Amanda?
All right, which one do you want?
I'll do whichever one you want.
You do the first one, the DCF worker assigned from when Sissy was a young girl.
Okay. DCF worker or attorney?
No, worker.
Okay.
Why, were you signing up for attorney?
Well, I thought you said you needed, look.
Yes.
2 DCF
Yeah, do you want to be
workers.
attorneys instead? That's
It doesn't
fine.
matter, whatever you want.
Does, I don't care, you tell me.
Okay, fine.
Here she comes, you guys can decide, I'll come back to you.
Do you want to be DCF workers? or-
Anybody want to be Carla, Sissy's great-grandmother? Oh, Jim, awesome.
Because you weren't here and I was here.
Then I need a guardian ad litem who's actually recommending termination of Sissy's parental rights. Stephanie? You kind of were raising your hand.
Kind of. Yeah, okay.
Yeah, okay,
So we'll be the DCF workers.
okay,
There's
so
2.
2 Amandas, all
One
right.
that worked with the family first and then one that worked.
Okay, so now I need attorneys, 2 for Sissy, 2 for DCF, 1 for the children. DCF, Joe, Joe and Mike,
Yeah.
I'll do
Well,
Sissy.
And then when she comes.
John, what do you want, Laura?
The children.
Laura. Did I just screw up? No, I didn't, because John and, Jonathan,
Me and Jonathan.
yeah, for Sissy. Okay, I got everybody, right?
Can we just run through it?
Okay, I'm gonna run through it again. Sissy, Jennifer. The court-appointed investigator, Christine Pashas, Nicole. DCF worker with the Harrison family, Amanda S. DCF worker assigned to Sissy when she becomes pregnant, Amanda P. Carla Harrison, the grandmother, is Jim. GIL is Stephanie. Attorneys for Sissy, John and Jonathan. Attorneys for DCF, Joe and Mike. Attorney for the children, Laura. Okay, so that's for Thursday. Now, Amanda, you can look on, because for some reason I didn't make enough
Here, I grabbed
copies.
her copy.
I grabbed her copy.
Okay, this is what I want to do, especially since I don't have a copy. Why don't
Here,
you?
there's another
No,
one.
no, I don't need it. I'm
No,
fine.
it's
No, there's 2.
extra.
How is it extra?
2
I had
people,
grabbed
2
one
people
for the
grabbed
other.
one for Amanda.
It's Jonathan's copy.
Amanda was looking out for you.
So I did make enough copies. Okay. Oh, Mike, you ask the questions to the attorney,
Okay.
all right? And let's have somebody that's further away from you. Amanda P., could you be the client? Mike is gonna be asking the questions, and you're gonna read.
Okay.
Okay, so we're gonna start with Mike saying, can you describe, actually, let me read the beginning part.
Okay.
So you, meaning Mike, have been appointed by the juvenile court as counsel for Christy Mark. And Christy is gonna be Amanda for now. Mother of 4-year-old Logan and 11-month-old Bailey. So this is pretty near the beginning. I know some of you have read all the materials on the actual case, but we're at the point when the children were taken. The children have just recently been removed from Christy's custody by DSS, or DCF obviously today, and the case is scheduled for a 72-hour hearing. The family has a history with the department. You've just concluded the following interview of your client regarding her case. Advise her as to her rights and responsibilities, predicting what might happen at the 72-hour hearing and throughout the course of this case. So let's do the script first, with Mike starting to ask the questions.
Can you describe the first time Diane Sanborn, a DSS caseworker, ever arrived at your house?
Logan was still in her crib. Andrew was sleeping. I had just gotten up. I had just put out my first cigarette and walked to the door. Like, who is it? She's like, Diane Sanborn, Department of Social Services. I'm like, what do you want? We need to talk to you, she said. So I opened the door, she came in, and Diane asked me all kinds of questions. She wanted to look in my cupboards, and she wanted to look in my fridge, and she wanted to see Logan. So I brought Logan out of her room, and I got her dressed right then and there. I didn't care that she was there, but I didn't hide nothing. I was feeding her the whole time she was there. Diane just asked me about my family background. She knew a lot about me. She was telling me what kind of trouble I was in when I was a kid, and like, wow, you know quite a bit about my life. She knew about Andrew overdosing on medication, and she brought that up. She asked if either one of us had a substance abuse problem. I didn't at the time, and I still don't. But I said no on my behalf and said, he's in St. Mary's Substance Abuse Counseling. She's like, okay, well, we want to keep checking in a couple months, in a couple weeks, and see how everything's going, and whatever. Didn't think nothing of it. She wouldn't tell me who had called. She read me this ridiculous report, something about that there were dirty bottles in Logan's room, and that she never had a bath. I mean, it was just, I sat back, I'm like, whoa. She said, somebody's lying, I don't know where you got the report. And then said, I think I know where you got it. She wouldn't confirm it, but she wouldn't deny it either, so it was one of those things.
Amanda, you tired? What?
No.
You'll keep going? Okay.
Who was it?
Don't be afraid to play the role, okay?
My mother, because she was mad because I moved out and I took Logan with me, so
So she made things up?
yes. Yes, but I forgave my mother over and over again.
Why?
I think I needed her, and she needed me for different reasons, whether it was financial or somebody to talk to, somebody who knew me, just different reasons, I guess. Wanting somebody there to talk to.
Did you ever tell yourself it would be different the next time?
Oh, every time. It's going to be different this time. She'll listen. She'll understand. And she made promises after promises. Oh, I won't do that again to you. Of course, it was always the same thing every time. I thought I'd learn, but
Do you blame her for the fact that the state got so involved in your life for such a long time?
yes, yes I do. You can forgive, but you can't forget. But you can only forgive her so many times. I'll never forget what she did to me.
DSS has laid out a lot of rules for you. I'm going to read you some of what they call the service plan between you and them. I just want to hear your reaction to this plan. It says, Christine will submit names of people or person with whom she is or plans to intimately be involved with, and shall not allow any contact between that person until assessed and approved by DSS. If there is a person with whom Christine wants to be involved with, then Christy agrees that if that person does not wish to engage in services, then that person will not be a part of Logan's life. They said that you must sever all contact with your mother. There were a lot of rules here. Is it hard? What's your reaction?
I resent all these rules. I feel as if DSS is too involved in my life. But as far as submitting names and everything, that wasn't a problem. I didn't have nothing to hide from them. They asked me frequently, are you involved with anybody? So I wouldn't lie to them, I told them. And more than 9 times out of 10, I wasn't. But not talking to my mom for the most part, I didn't because I wasn't supposed to. But I kept in contact through friends of hers and mine, mutual friends, to let her know what was going on with me.
I guess I'm more asking you, not so much whether you kept the rules, but whether it made you angry that you had so much.
Yes, oh yes, angry, somebody else was running my life. I was just a person following rules. Wasn't my direction, wasn't my thoughts, my opinions, it was theirs. It made it really hard to have your own life, but I managed somehow. Angry, that goes without saying. I think it was more hatred.
I'll read the note. Note, while Logan was in DSS custody, Christy had another baby, a girl named Bailey, still forbidden from contacting her mother. She got an apartment for herself and Bailey. After 7 months, satisfied Christy had changed DSS, returned Logan to her and closed her case. Christy then decided to move with Rose to Florida to stay with her estranged father. He had become alienated from the family after a bitter divorce, during which Christy accused him of molesting her. He denied the accusation, and Christy later recanted.
When you decided to go to Florida, you were going back to somebody whom you had accused of molesting you as a child. Despite the fact that the department didn't want you to go, you determined that you were going to go. What did you tell yourself? How did you explain that to yourself? How do you explain that now?
How do I explain it? I always had this demon. I always looked at him as a demon. I was always scared to stand up for myself and say, no more. Well, I figured I was a big person now, and I wanted to do this for myself. I think it was more for my self-esteem than anything.
Do you understand why somebody would say you were putting your own need before your kids? That you were exposing your kids to somebody who could hurt them?
I do. That's the sad part. Sometimes you have to take care of your own needs before you can take care of your children's. But that was a hard choice to make. It wasn't an easy one to go down there. I originally didn't want to even take my kids with me. I wanted to leave them back here in Massachusetts so I could do it. But I couldn't be more than 5 minutes away from my kids. I just can't. It bothers me too much. I worry too much. So I figured if I took them with me, they could be safe because I wouldn't let anything happen to them. This time I was an adult. I could take care of them. It was a poor decision and a bad risk, and I knew that. I understand why there's conflict with that one situation. But I think I needed to do it to get on with my life. Unfortunately, the department can't see it that way.
So Christy returned with her children from Florida after 9 weeks, moved in with her mother, Kathy. She began a relationship with a new boyfriend, Paul, a convicted burglar. Concerned about both her living arrangements and her new relationship, DSS reopened her case when a new caseworker received an anonymous report, never confirmed that Paul had hit Christy in front of Logan. The caseworker moved quickly to remove both girls from Christy's custody.
Can you tell about how the children were taken from your home? Tell me the story.
Logan was sick. She was sleeping on the couch. Bailey had just gotten up from her morning nap. Paul had gone in to go get the baby to bring her out, and there was a knock on the door. It was 11:30 in the morning, and I remember them walking in. I didn't have my hand on the door yet, and they just walked right in. There was 2 caseworkers and 2 cops. There was one in uniform, one out of uniform. I said, yes, can I help you? I knew who it was, knew the caseworker right by her face. She goes, yes, we're here to take your kids. I'm like, excuse me, why? It's in the affidavit, read it, get their things together. I'm like, you can't do this. She goes, oh yes I can, and I'm going to. And she did. I got Logan up, and I woke her up. She looked at the caseworker, and she knew who she was. She knew why she was there. Logan started screaming, no, Mommy, don't let them take me. Mommy, please don't let them take me. I told her it was going to be okay. She's like, no, Mommy, don't make me go. You're talking about a 4-year-old who's sick with the flu, you know? I barely had time to pack a small bag for each of them, and they were gone. I carried them all the way out to the van. I was surrounded by 2 cops and 2 caseworkers. One, the caseworker herself, jumped into the van in the driver's seat, and the other one was in the back seat with the kids, trying to get them buckled in. They slammed the door, and she took off. I remember I fell to my knees and I cried, dear God, no.
Okay, so Mike and others will help you as well. Since the question at the beginning calls for you to now advise her about her rights, her responsibilities, predicting, so what's in line right now is a 72-hour hearing, but, you know, take it into the future and advise her, you know, about the course of the whole case. So let's try to take it apart point by point as to what you might advise your client about. And in a sense, it's a review of what you guys have read up until now, and it's a little bit of a review for exam time too. So when I give you fact patterns like this in the exam, always look for the call of the question. So this question might have been something different, like you represent DCF. What's your case? Are you going to be able to, meet your burden? Or it could be you're in the judge's shoes. What would you decide? What would your findings be, et cetera. But again, this says advise your client basically about the whole case, about her rights and responsibilities. She may not even know about how do these cases even start, even though she's been investigated by DCF over a period of time. This isn't the first. She may not also know about the reporting process itself. So anytime you get a question like that, where you're advising a client about a care and protection case, you might start just at the 51A reporting process. So let's start there, okay? So how would you explain to Christy the 51A, reporting process, how DCS, got DSS, I'm sorry, I'm saying DCF, combination of DCF and DSS, the department got involved, with her family, both in the past and right now in the present, because that's what's looming, the 72-hour hearing. But before we talk about the 72-hour hearing, I think we should start explaining to her, well, this is how DSS first got involved, and how did DSS first get involved. You can even do it with this latest fact pattern. Okay, what made, up until the point of time that the workers, and I forget if they came with police or not, come to her house, there had to have been a report. So let's start with that report. What would you be saying to her? Anybody want to start, or do you want to start, Mike?
I think I can do this, sure. So essentially in these types of cases, the department will get a report which could come from any source. There are some sources where mandatory reporting sources, but it could be reported from any person that feels there's concern, and that's called the 51A report. And essentially the person that receives the call from the department either has to screen in or screen out the report as to whether there's an emergency need for intervention by the state on behalf of the children.
So let me play Christy for a minute then. Let me play Christy. They lied. Somebody said that Paul was hitting me?
Well, that frequently happens, is that information isn't always necessarily true. The reality with these 51A reports is that the burden of proof is very low on the state's, they only have to have reasonable cause to believe that the alleged report had happened. And that's a very low threshold for them to meet. And if they do determine that there's an emergency need, then they send a worker out immediately to investigate what's going on.
Okay, let me stop you right there. So that's the next step where you talk about 51B. But does anyone else want to chime in and say anything else about the 51A report itself? Laura?
As he had mentioned, reasonable cause is a very low threshold, and it's for physical or emotional abuse.
Who needs reasonable cause?
It's actually the court.
Steph?
It's actually the court that needs that.
Okay, we haven't gotten to that point. We're only talking about a 51A report. Who needs reasonable cause?
The person
The
who's
process,
reporting.
the interview process, of taking the call from.
No.
No, the person
No.
who's reporting, like they
The
have.
reporter,
person
the
who's
reporter. So, and you said mandated, and in this case it wasn't, allegedly, we don't really know, because even though Frontline had done this huge report, obviously, a lot of the information is closed, closed files, so we don't know who made that call, that allegedly, Paul was, that there was domestic violence going on in the home, whatever. But as you explained to her, the reporter could be somebody who's mandated, or any person, but it's the reporter okay, under 51A, that has reasonable cause to believe, right, that a child is being abused or neglected. And so the reporter remember, we've talked about it, follows in writing if that reporter is mandated. And Mike, when you said the investigator at the end of the line, what's the investigator's job now at the end of the line? Listening to that reporter.
That's where they have to screen in or screen out.
Screen in or screen out. So what would you explain to Christy about this screen in or screen out process that happened in this latest version of her relationship with DSS?
Well, relating it to your past history with the
No,
department.
because the reporter is just hearing this.
The information.
Yeah.
So if they feel that it warrants an emergency need for the children.
No, just screen in or screen out first. Are you gonna screen it out? You're not gonna screen it out
No,
because.
it's an alleged domestic violence.
Okay, and couple that with what you just said,
And
that there has
the
been
call
history
back.
as well. You could also be explaining to her that because she's got the involvement with DSS, she's already in the central registry, and there would be a check on that as well. And you're right, I'll take back what I just said, because that would come into play in the decision, right, to screen in
I would
rather
think it
than
would.
screen out. You wanna add to that, Stephanie?
No, I just have a quick question. I know that there are some times when allegations are unsubstantiated, and which basically means they don't hold. to
Not
the
yet. That's after the 51B investigation.
Right, but I'm just
Yeah,
asking a
go ahead.
question related to this. Let's just say in the past, there were allegations that were unsubstantiated. Does that take a place, does that take an effect, or into account with a new allegations for 51A? Like, in other words, do they get that far?
Good question, because you could still be in the registry because the
Right.
period of time may not have passed.
Right,
Yeah.
so I'm wondering,
Yeah.
do they take into account, even if, in the screening in and out process, do you know if they take that?
Because, they're human beings too,
Yeah.
that are following what appears to be, set rules and procedures. But you've seen so far that on the one hand, they appear to be, like I said, rules, procedures, blah, blah, blah. But on the other hand, they also appear to be subjective. They carry a bit of discretion on the part of whoever's carrying them
Right.
out.
The person.
Yeah,
the
so
person.
there's really, I'm sorry, but there's not a good answer to your
Okay.
question. It's a good question, but,
Okay.
yeah. So, those are the things that you would explain about the reporting, and you may also, tell her about that this has happened before, when Logan was quite young and when she was ultimately taken. But actually, you're now concentrating on the upcoming 72-hour hearing and the course of that.
I have a quick question.
Yeah.
So let's say, obviously, I think in this situation, they wouldn't screen it out, but let's say that they did. How long does that stay on file in the system? So that if a month from now,
Oh, a
of course,
screen out is
another-
nothing, there's nothing on
It
file.
never ever goes in the file?
No. But another reason why you might have been screened out is because there might have been multiple reports.
Right.
So it might have been a neighbor, a preschool teacher, her mother again, right? So some of the calls may have gotten screened out because it's the same
And
report.
how do they, so unless one of those was already screened in, how do they know?
That's true, unless one of those was already screened in and there was an investigation going on, then.
Then it wouldn't be
then-
screened out for that
Exactly,
reason.
yeah.
All right,
Yeah.
so in other words,
Yeah.
if somebody, maybe 3 or 4 people call and it's something that each time it gets screened out, that doesn't ever get tracked, that maybe after 3 or 4 times,
Probably, Mike, probably somehow.
not on the books.
But yeah, exactly, yeah. So 51A, then you're gonna now tell her about 51B, and now you're gonna get into what you started to say, that it was screened in as an emergency, et cetera. Amanda, did you have a question before we get to that point?
When
So
they-
just remember, if you're taking it kind of step by step, what we just talked about was merely the report and what happens when someone reports.
When they're at the point where they're either screening in or screening out,
Mm.
do they take into account whether it's a mandated report or whether it's just a neighbor
Well, if it's mandated, it's gonna be followed, remember,
So that's
with
definitely
something
followed up.
written as well, yeah.
And they need one is definitely, but if it's just some neighbor calling, they, like, or what is the percentage that they're screened out versus?
I have no idea.
No?
I don't know. All right, 51B,
Okay, so if they decide that,
so talk to
The-
Christie. Again, the reason why I'm making you talk to Christie is if you were answering this as an exam question, you would be saying things like, I would advise my client about the 51A reporting process, I would be saying that blah, blah, blah. So you wanna put it in the context of advice to, obviously a layperson, but you're giving enough of the legal stuff so the layperson understands it.
all right. So if they felt there was enough of a concern from the 51A report, they would then do what's called a 51B report, and determine whether.
Let me just stop you for a second, just so we can be clear, so the 51A is the report. Once it's screened in, now the department actually has a duty. So, even though, obviously she's slamming the department, she hates the fact that the department took her kids. But you also have to be careful that you're not as emotional as she is. Oh yeah, I hate the department too, when am I gonna get that? So because you're giving advice, you want to also keep it in an objective manner. You're not, your audience is not the court now that you're trying to persuade. So, you're advising very well, this is what DCF, what's the screen, they had no choice. They had to investigate this 51A report. Go ahead.
Okay, so at this point, the department has a duty to do what's called the 51B, and that can either be an emergent or non-emergent situation. If it's a non-emergent situation, if they feel that, there's no immediate need for the children, then there's an assessment that's done, and then within 45 days, they have to do a service plan with you, the parent, on how they feel
But
they
why
can
were
help
my
you.
kids taken? Basically from sleep practically.
Well, since your kids were taken, this would lead me to believe that this is an emergent 51B, not a non-emergent. And under an emergent 51B process, they're going to come and remove the children, and then you're entitled to a hearing on the first day that the court's open after the kids have been removed.
So again, you're not answering my question about the client. Why were my kids taken? You want to explain to her the standard. What's the standard, Laura?
Reason for
Mike is right, it was screened in as an emergency, but
Yeah.
once the DCF goes there, right?
Still.
What is the reason why, according to the department, those kids were removed that morning?
So it's still the reasonable cause test?
If you can articulate it.
Yeah, so it would mean that because of, the situation, they're at some risk of physical or emotional abuse or neglect.
Well, how would they, again, I'm Christie, why? Didn't they have to go to court before they could take my kid? She just rattled an affidavit at me, and I know she didn't have a court order.
Right?
What gave her the power to just take my kids without going to court?
In an emergency situation, they don't need to go, they can come, they actually are required to come and begin the process within 2 hours and make their initial determination within the first 24 hours. And then they owe the final investigative report within 5 days.
What else can anybody add to that?
I probably would just say, the allegations, indicate there's a safety issue, and it's our duty to make sure all children are safe, and until we can, probably kind of make her feel as if we're gonna continue to keep the children safe, and we'll get this handled as quickly as
That
possible.
you make her feel that it was the department's duty to do this,
Yes, because there's a question of safety for your children.
because because it's the department's sort of assessment of the
Right.
situation. Obviously,
Right.
she doesn't think that they were
Right.
in
Right.
danger,
Right.
but you're explaining to her the process. They didn't do anything
Right.
illegal in terms of following sort of rules and regulations. It doesn't mean that eventually, so you might, in answering this and also in advising the client, you may come to a conclusion that doesn't favor your client because you're giving advice based on the law and the facts that you have, or you might come to a conclusion because all you can do is predict, because you know the law, hopefully. You're hearing your client's story, which is just a story right now. You probably don't even, you may have the department's affidavit, you might not have anything, other than sort of your appointment sheet. So you might conclude favorably to your client or unfavorably to your client, but either way, because you're giving advice, you want to be as objective as you can in sort of going through the law that's applicable to her situation. And all you're doing is trying to predict, right? Trying to predict based on what you're hearing from her so far, trying to predict what, the 72-hour court might do and then later. So we're at the stage, so we've explained 51A, we've explained 51B, DCF's, duty, police power of the state, emergencies, Mike?
So when they just sort of came busting right in, does the court consider that exigent circumstances to come in to get the kids?
Emergency, okay?
When they
And
did
it's
knock and, the police and the workers came right in the house and just.
Well, again, this is what Christie is telling you too, your client, that may or may not have been the case.
But in general,
In
would that
general,
be what
they're
they
gonna
would
knock,
consider
they're
as
gonna
exigent
knock, they're gonna
circumstances?
announce who they are, and, we come, and usually they will look around, they'll speak to everyone. But again, that was Christie's version of what happened that morning, and it could have been that way.
Does that mean if they, let's say they didn't, right? Let's say her story was true, they just come walking in the door. Would, sort of the regular criminal procedure, if they found like incriminating evidence while they're in there seizing the kids, would they, would she be able to file to have that stuff suppressed, that they couldn't use that as evidence against her? Because they,
Well, when you say suppressed, you're now talking about a criminal case. DCF's duty, DCF's goal, responsibility has to do with families. So even, if they see marijuana on the table or something, obviously, in some way, you might have, the criminal prosecution, but really wouldn't have anything to do with DCF.
That process.
Yeah, only in the vein of when you get to trial on this, does it go to, unfitness and so forth and so on. But frequently, if it is screened in as an emergency and it looks like it's gonna be that kind of crazy difficult case, it's not gonna be just social worker knocking on the door. Police is gonna be with him or her, obviously, because no matter what, it's a traumatic event. And if DCF is already thinking that they're probably gonna be pulling these kids, they know that there's gonna be some craziness associated with doing it. And because, again, DCF not being a prosecutorial agency is still using sort of like the police power of the state generally to take the kids because they don't have the custody. That's why when Christy asked you, they don't have a piece of paper from the court. Well, they don't need to because it's an emergency, and the courts in both the courts and the legislature have given DCF sort of this authority, but it's short-lived. And Mike, you mentioned that they have to go to court the next business day. So you would be saying to Christie that, and you would lead into that's why I've been appointed, because now you have the opportunity to go to court and have the judge, decide this. So you could be talking to her about a number of things. For example, she might not even be entirely cognizant of the kind of the definitions of neglect and abuse. Anybody want to tackle those and where they come from? And you don't have to be exact, but generally speaking, because we talked about the 51A report, it's a report of neglect and abuse. And she says, well, what did I do? What is neglect or abuse? Or what did I do supposedly in this last version of events where I had Paul living with me? Stephanie?
So, in general, typical abuse would involve doing something that you're not supposed to be doing, whether it be verbal, or emotional, or physical, meaning that you are imposing a harm to that individual, namely your child. Neglect, on the other hand, is not doing something
Good,
that
that's a
you're
good way of putting it. One is an act, the other is a failure to act. Where are they defined, by the way? Do you guys know?
51P.
John?
Chapter.
51P.
Actually, remember the not,
Chapter
Ten,
119, chapter,
what?
is it chapter? Yeah.
They're in the regulations.
Yeah, they're not
110
defined
CMR,
anywhere, John,
Section 2.
other than the
Yes.
regulations of DCF.
Yeah.
When it comes close to 51P, it says the department shall immediately report to the district attorney and local law enforcement when there is reasonable cause to believe that one of the conditions below resulted from abuse or neglect, and it goes over to like a bunch of scenarios.
Yeah.
So that's not considered abuse or neglect?
No, it definitely is, but the definition, per
Okay.
se, of these two terms, now think of it as, so this is the agency, and we're doing agency law right now as well, and we're doing administrative law in this course. DCF being an agency that's entrusted with the strengthening, encouraging family life, helping families, protection of children, enacts their regulations. So it's their regulations that define what abuse and neglect is. And they obviously have to then follow the statutory procedures as well, the statute that gives them the power to act as sort of like a super parent. So you could be talking to her about what neglect. How about in terms of her actual case? So again, you have to phrase it in such a way that, she doesn't think she's neglectful or abusive to her children, but you could explain to her how DCF perceives it. So based on this latest situation, what would the abuse or neglect be, Stephanie?
So, the thing that I see that would sort of stand out most is her, the mom allowing her children to be exposed to sex offenders and criminals would probably be the biggest thing that they see. For her to constantly putting her child at risk by allowing them to be around certain people who have those offenses will be seen as a poor sense of judgment. And if she has a poor sense of judgment for this, then obviously her parenting skills may not be what they should be in order for her to have children. So that's probably the number one thing that I could probably see they would argue.
Okay. What else about Paul? I'm sorry, about Paul, that also raises a flag in the department's eyes.
Convicted burglar?
That's the
Yeah, I'm going
point
at-
that Stephanie was
Yeah.
just
Oh.
making. What was the report?
Just the
Domestic
best-
violence.
Yeah, so again, you should be discussing that. That may not be the case here from what you're telling me, but it is the department's obligation, and there is, law, case law authorities on the effect of domestic violence on children, and that's why they're following up, and that's why allegedly they've taken your children. What about some sort of specific rights statutorily that she has as a parent, and now we get to the court stuff, as a parent in a care and protection case?
Well, she has the right to counsel.
Yeah, and you're a counsel, you're appointed, and what else does she have in terms of sort of due process sorts of rights?
The right to call witnesses.
Oh, obviously, in the trial itself,
The right to notice.
notice, of course, to notice. So now, and she's gotten her notice, how would you explain to her this upcoming 72-hour hearing that's so quick, right, after the
Not
case
necessarily.
itself? After the case itself was
If she
filed.
needs a little time to get things in order, we're gonna do our best to push that out. Well, the 72-hour hearing, the state has the burden to show by a preponderance of the evidence, meaning more likely than not, that there is
So
a.
you would be saying, even though, I mean, that's a legal term, the client might not understand, but then you said more likely than not. So that helps her, at least a little bit, to understand what that means. How would you explain like the burden that you just said?
They have to be the ones to show it, so they have to show the need rather than you showing there isn't a need.
Besides they, let's say the department.
The department has to show that more likely than not, your children are in need of care and protection.
Okay, let's back up for a minute. So when the social worker took the children and went to court the next business day, right, and started the case rolling, how would you explain the beginning? The petitioner, the filing of the care and protection petition? Joe?
I mean, it's based off of reasonable cause, and then once we get to the 72-hour hearing.
Okay, but you need to explain this, what's based on reasonable cause. So you just said to your client, listen, they took your children, blah, 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 these are the rules, this is the statute, the reporting statute, this is what DCF did when DCF allegedly investigated this abuse and neglect, and then this is what it means, et cetera. They went to court and filed what? What action is pending against her? What exactly, Jim?
File the care and protection matter.
So how would you explain what that is?
I guess in layman terms, I try to explain to her that it's a summons that's brought before the court that explains the.
And think
DE.
of that first paragraph of 119.24, but to put it in layman's terms.
Would you
A
say it's a
petition.
temporary order from the court to take away your rights?
Well, it's not an order yet, if you're
Well, that's what
going
they're
to.
seeking, is a temporary
Yeah.
order from the court to take away your rights to the kids.
They're seeking a temporary order, certainly, because it's a long time until the case goes to trial, but you're jumping ahead. What are the allegations of a care and protection petition? How do you explain what exactly that is? So this layperson knows nothing about what a care and protection case is. Nicole?
The children aren't receiving the necessary, care from you. The department feels they need to protect them from you right now until things get better.
Yeah, and that's the petition. So you could summarize that, pretty much that first paragraph. And it's a complaint. Yes, it's a complaint, not necessarily filed against you, right? Because it's a case, care and protection case is a case about a child or about children. And as you said, seeking, where the department or whoever the petitioner is seeking custody, and seeking custody because at this point in time, the parent or parents are allegedly, for various reasons, right, unable to provide parenting. And some of those reasons could be, the neglect because of domestic violence, or if it was a really serious case of physical abuse, you could explain to her sexual. There's some really serious cases that are filed. There are also cases that are not that serious, but for whatever reason, the department has made it its mission, lack of a better word, to file a petition to get temporary custody. So then you would go to, once the filing and the first hearing happens right away, right? So the worker would have gone in the next day. Mom's not there. No one's there. The department's attorney isn't even there, and even if he or she is, they know nothing about the case. So you would explain to her, and how would you explain to her, Nicole, about that first emergency hearing?
The 72-hour hearing?
No, the emergency hearing. I'm going in, I'm filing my petition, my affidavit, I'm going before the judge to get that emergency now order under 11924.
Okay, the emergency hearing is basically when the department goes in and talks to the judge, basically asking
Okay.
for permission to take custody of him.
Okay.
And it's usually just that, right?
And it's usually, so you would be saying, it's usually just, I wasn't even there, I get appointed, as a result of that. And the judge listens to the social worker's version, and the reason why, again, is because it was allegedly an emergency, and they're going now to get this emergency temporary custody order. And as you said, Mike, and remember I said to you that the reporters report because there's reasonable cause, now the judge uses that same kind of standard to issue an emergency temporary order of custody. The judge is assured, hearing the worker's version, that there's reasonable cause to believe that your kids would be, neglected or abused as a result of staying in the home, at least at this time, temporarily. Now you're gonna get into the upcoming 72-hour hearing, because that's the next step. Are we missing anything yet? Okay. So, how do you explain, I'm sorry, so you would have said that, that you got appointed, so when you were talking about right to counsel, you could tell her as well that, suppose, she was married or there was a bio dad around.
entitled
You would tell her
to
that,
separate counsel.
yeah, the dad would get counsel, that,
Logan would get
that,
counsel.
both Logan and Bailey, either got one attorney together, if, or they may have separate counsel, so you might even explain that happens in some cases when kids have sort of differing interests and issues. You would also explain that the court appoints, as a matter of course, the court appointed an investigator, and sometimes, because that's not always the case, sometimes a guardian ad litem if the court needs a best interest person in there besides the child's attorney. So you can get into, a role of counsel as well in answering her question. So now, let's talk about the 72-hour hearing. And you started to before when you said the department. So how would you explain, Laura, about the burden that we just started to talk about that the department has at the 72-hour hearing?
Yep, so that's where the department has the burden of proof. And it is that preponderance of the evidence, meaning more likely than not.
So how do you explain to her what it is the department has to prove at this hearing?
Whatever their so there's a concern that the children aren't being parented in the right manner, and so it's the department's
So
burden.
how could you make this specific to Christie's, the history and the right now happening of Christie's relationships? Nicole, you just raised your hand, that's why I looked at you.
Okay,
But-
the 72-hour hearing is where, based on your history with the department, based on, what you're doing currently right now, it shows that there could be a more reasonable than not, chance that your children are in danger, and until, you show that you are not going to cause a danger to your children, the department is going to ask for temporary custody.
Okay. You want to add to that, Mike?
Yeah, just if there's a continued need for custody.
Okay. Mm-hmm. Explain.
Well, that your circumstance hasn't changed, that,
Since the taking one day ago, you're saying?
well, it could be 3 months ago.
The 72, yeah, so you could explain that, listen, we're doing court, Wednesday. If you need more time, we could ask for more time, but according to the statute, the reason why the court can hold what's really a full-fledged trial is because, and then you can get into parental rights, is because, your rights are so important as a parent that you shouldn't, have to wait a long period of time while your children are in the, temporary custody of the department, until the department, can at least prove by, more likely than not, preponderance of the evidence, that continued custody for now, would be, safe for these children. So you could be getting into that conversation as well with the client. Stephanie?
Just wanted to add that in cases like this, where there is history of domestic violence, or
Yeah.
if that's one of the reasons or primary reasons why the children were removed, one of the first things they look at is whether or not that relationship is going to continue
Yeah.
within the home.
Mhm.
So part of the continuing 72
Mhm.
is that a parent has to make a decision, are you going to still live together or not?
And that could be a tricky conversation
Right.
too, that you're having with your client, whether your client is actually married to the person that might be battering her, or not. Either way, it's someone she has a relationship with. Yeah, good point.
And usually
Mhm.
that's kind of a big question for the parent, in this case Christy, because she's basically choosing between her kids and her boyfriend, so to speak, and to make that decision, we know that later on she marries him, but that heightens the risk
Mhm.
the department has to face
Mhm.
if she does things like that, so then they'll further prove that this is why we need to keep the kids safe.
Yes, yes. The other thing is that, should this 72-hour hearing occur, quite quickly after the filing of the petition, remember that, you also have to look at the agency's, what's going on in the agency. So, at the end of the 51B investigation, obviously, the report was substantiated, but that wasn't the end of what the department is doing agency-wise, right? So now there's this assessment process that's going on, and it's going on longer than the holding of the 72-hour hearing, if you know what I mean. Because the assessment takes more than a month. The service plan is like 10 days after that. So this, at least the first service plan as a result of this taking, is gonna be like almost 2 months later. And that service plan could be some of the factors that Stephanie just talked about, related to domestic violence issues. So you might also be talking to her about, I know you're familiar with service plans because you talked about the past service plans you had. Well, now there'll be a new service plan coming up as a result of this particular investigation. And it may include, get Paul the heck out of the house or something like that. So those are points that you would be talking about with her as well.
And is that where,
So-
like I mentioned, where if she did need to get some of that stuff taken care of, that you tell her, we may want to try to push this off a little bit for you to get some of this stuff together? Like that whole, if you can't win it, don't have it.
Exactly, sure, if at least on your sort of quick assessment on meeting the client for the first time, you say to yourself, oh yikes, this is gonna be a tough one. Of course, she's got the right to the 72-hour hearing, and she doesn't have to do anything, it is the department's burden, but at the same time, if it doesn't look, because you're assessing and you're predicting, right? If it doesn't look like a case that the department wouldn't be able to meet its burden, maybe you would, as you said, might want to sort of put it off or waive the 72-hour hearing. So you could talk about that as well. Listen, you do have the right to the hearing, but, based on what you're telling me and my reading of my look at the case so far, it looks like the department, might meet its burden right now. You might not want to have the court, hear all these facts. It doesn't mean that you've lost, your parental rights altogether, et cetera. Yeah, so that could be something that you want to talk about as well, whether you want to go forward in the 72-hour hearing or not, depending on the facts. One other point related to the 72-hour hearing, and that's the 11929C. Remember that besides meeting its burden by preponderance of the evidence that the children would be neglected or abused, or, if returned to mom's care. Remember, the department also has to show that reasonable efforts requirement. And it might actually be, unfortunately, easier in a case like Christie's, where there's already history with the department. So you could maybe be talking about that to her, defining what reasonable efforts mean, and how the court really has to certify, it's a 29C certification sheet, that before the department, pulled these children, the department in fact had made reasonable efforts. So again, depending on the facts of a case, that could be the nugget that you actually win on or not. So it's not only preponderance of the evidence, it's also, in the 29C, has the department made, reasonable efforts before pulling the children. So then, if you're gonna now talk about, I know that I wanted to advise you pretty much about the whole case. So, depending on what happens at this 72-hour hearing, and if the case doesn't, go away and get dismissed and you get your kids back right away, we now have a long haul, right? So what else would you tell her now about the future of the case? What happens after a 72-hour hearing? Amanda? Either one? The two Amandas.
Well, then it goes, you go to have the trial.
Okay, so just before we go to the trial, remember you talked about the investigator that got appointed. So the case is at least gonna come before the court, within a month probably, because the investigator usually has somewhere between 30 and 40 days to put in his or her report. And you could explain also what the investigator does. The investigator doesn't represent the department. This is the court-appointed investigator, not the, and that's what people sometimes get confused about. So it's not the 51B worker that substantiated the report. This is somebody that's really, and think of it, you would tell your client, think of it as an arm of the court. The judge can't go out and talk to everybody and figure out the facts and, make a recommendation, blah, blah, blah. So it's someone that the court is appointing as an arm of the court to investigate the facts, talk to everyone. So you could also be asking the client for collaterals that she might want the investigator to talk to. Well, they should talk to my sister. She knows the whole story, and and Logan's teacher, and so forth. So you would explain to the court investigator, and that we even though you might lose custody at the 72-hour hearing, and trial isn't going to be for another year, we'd also be coming before the court at various times. So one time for sure is for the investigator's report. We can also come before the court, you could tell her, when the department is screwing up, right? And that's when you can talk about the abuse of discretion hearings. Listen, even though you've lost custody, the department has obligations to you, and the obligations should be in the service plan as well.
Like visitation.
Exactly. So and you could say, for example, Christy, if you tell me that the department isn't letting you see your kids during the pendency of this care and protection actions, they possibly are not following the law, and that would be my job to bring it before the court on what's called a motion for abuse of discretion, because DCF is not following its rules and regulations about affording visitation, or whatever the issue might be. So that's another spot in time during the pendency of care and protection case that you might be going to court on. The other thing is, now she's got a worker, assigned to the family, assigned to her. DCF worker will also be submitting reports to the court. So sometimes you're before the court on just, not a real trial, but what has been sort of called a status hearing, where the attorneys and the workers are just like filling in the judge as to what's going on. And typically the worker also submits a report to the judge, bless you. And under the statute 119.21A, the DCF worker as well as the investigator are these qualified sort of experts that could ultimately and would, testify and be subject to cross-examination, obviously, by you. So those are some of the things that you talk about before you get to talking about the final trial. So let's get to the trial, Amanda, that you started to talk about.
Okay, and then the trial is for determining whether to return custody to her.
Well, remember, instead of wording it that way, remember that DCF's the petitioner. And so you're always gonna be talking about what the petitioner has to show. So remember in the 72-hour hearing, you were saying petitioner had to show certain things. What does the petitioner have to show at the final trial? What is DCF, Jen? So if your case goes to trial, Christie, and now DCF is gonna be looking for, permanent custody, and you might get into termination of parental rights, but hold that thought for a minute. You'd be saying to her, DCF has to show that, what?
There's clear and convincing evidence that the home is unfit for the child.
Not the home is unfit,
The parents are unfit.
that you are unfit,
Parents are
right?
unfit.
So current parental fitness, right?
Yeah.
The standard for DCF, the petitioner getting now permanent custody as a result of the trial. So then you might explain to her, cases, or just in general, because it's a client, so you don't have to be that specific, but what fitness means, and, the case law has held that, for example, drug addiction alone can't be it. It has to be the relationship, the nexus between you and the child. So you might be generally defining what fitness or unfitness is. And that then you get to the adjudication, and if that's the case, and remember that it wasn't, you're not the defendant in this case, this was a case about a child, so the adjudication, the decision becomes that the court adjudicates the children in need of care and protection. That's why they're called care and protection cases. But that doesn't end the trial. The court now has to look at disposition, what to do with the kids. Mike?
So when you're trying to explain to the layperson about clear and convincing evidence,
Yeah.
would it be appropriate to say it's a much higher burden of proof than the prior hearing, almost like beyond a reasonable doubt, so there's
Yes.
no chance that it
And-
didn't happen,
Right.
but not quite there?
Yeah,
Would
and
that
in
be like-
fact, the Robert case even explains it that way. And mostly people, they know beyond a reasonable doubt because people watch crime shows on TV or they're related, whatever. So it is easier to do it that way. Look, it's still, it's gonna be harder with DCF once it gets to trial because they really have to show what we've called clear and convincing. So it isn't like a criminal case where the petitioner has a really hard burden to show, but it's much harder than they have to show at the emergency or the 72-hour hearing, right? So how would you explain the possible dispositions? What happens from sort of least worst alternative up to worst alternative? What would you be saying, Jim? So kids the DCF proves its case. What does that mean for these kids? What does that mean for this parent? How would you explain to client, what are the possible alternatives that the court would look to regarding her kids if she loses?
If she loses custody, the court may look to placing the children with another family member, and would determine whether.
Well, hold your thought about placing with a family member, because one thing we did talk about is that sometime during the pendency of the trial, she might, remember you guys read the Manuel case, she might be actually requesting someone as a placement for her kids, before the case goes to trial. And DCF might be fighting about that, and you might actually request what's called a Manuel or a placement hearing. But at the conclusion of the trial, because the DCF is the petitioner, DCF gets custody unless she loses, okay? So, and worst alternative is that her parental rights essentially terminated. But you would explain to her that she would know that, and it goes back to her rights about notice, right, Mike?
At that point though, would you also explain that worst case scenario, they could also take away her needing to consent for adoption?
That's what I just said, her parental rights get terminated. I said it more in a layman's term, and yes, it's a petition to dispense with parental consent to adoption, which means your parental rights get terminated. But that's the worst alternative. Notice that when we talk about notice, when you got the notice of this case, the summons says this could be a case. Remember, it was in 1924. This could be a case where your parental consent to adoption is dispensed with. So you know from the beginning that that might happen, and you wouldn't be, and Christy, you wouldn't be surprised at the end, because if that's DCF's goal, you will learn about it within the service plan. So the service plans come out about every 6 months or so. So if they change their goal, they're going to tell you. You're not going to be like surprised at the end. Oh my God, I lost parental rights and I didn't know it. I just found out at this trial. No, you're going to know that that's what they're going for. And then we could talk about, you know, what our strategy, you know, would be.
That goes all the way to best
Trying to
case
think this-
scenario, which is they can't prove their case and you get your kids back.
Exactly. If it does go to the court looking to see whether your parental rights are terminated, Christy, remember I talked about current parental fitness, the court now also looks to the best interest of the child standard. So you would explain kind of what that means as well. And that sometimes the two are so connected, because you can't take a child alone and say, oh, the child would be better off in this home. You have to connect it to the parent's fitness toward that child as well. Is there anything we missed?
I think there's,
Yes.
we probably said it already, but the only little thing that I see here is there's a duty on the court's part to make sure that the department does its job of helping the parent get the services they need to have the reunification process take place.
Okay, it's not so much a duty on the court's part. When I talked about, for example, if the visitation was an issue, with DCF had stopped visitation violating its policy, it actually would be the lawyer's sort of role.
Mhm.
If DCF is not following its goal of
Right.
helping families, it would be then the lawyer's job to bring it to the attention of the court, but the court can't act as, remember, it gets into sort of separation of powers. So the agency has custody, the agency has the right now as parent to do, you know, what's, you know, sort of best for the child. But if the agency is not following the law and has abused its discretion, then the judge can override it. But the judge can't really make sort of direct, you know, can't become DCF. So you have to be careful in the way that you the way that you put it.
So when you're talking to a client, as far as the wording is concerned, wouldn't it be beneficial to let the client know what their rights and responsibilities are and focusing on the responsibilities? Like
Yes.
if a client is really resisting, it's gonna make them look pretty bad, but at the same time, the department has to do their jobs about getting. the
Absolutely, absolutely, and that's the tough thing about these. On the one hand, yes, the department has service plans. In fact, if the department is gonna seek, you know, to terminate parental rights, some of the factors the court looks at is, you know, were you cooperating with the department? Did you avail yourself of the services, et cetera? But at the same time, if the client is contending from day one, screw the department, I did nothing wrong, then the client doesn't want to work with the department, and, you know, I mean, these cases are adversarial, you know, much as you say, oh, DCF, you know, they're here to help families, et cetera, they're still adversarial cases. They're really tough. Really tough. And sometimes time has a way of sometimes helping you, and some, you saw when we talked about the Linus case, sometimes hurting you. Laura?
This is just a nuance, I'm trying to get straight in my head. The possible dispositions, are there
Yeah.
4 that you?
Yeah, that's the 26 A, B, C, D.
Okay.
Yep.
Okay, thank you.
Sometimes you hear, juvenile courts are also courts of equity. So it's sort of this like catch-all when you think of, you know, what justice means in capital letters. You can always sort of appeal to, you know, a judge's sense of equity, and this is an equitable court, and you can grant blah, 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 you know, something that's not specifically in a statute or in case law. So that's something to think about as well. If you had talked about all of these things in exam answer and had time to write it all, and did it clearly and logically, it would be a really good answer.
All right, we'll do that, just give us one question.
And typically, just to think ahead to the exam, by the way, it's already on the schedule, Wednesday, May 9th? I know it's a Wednesday at 6 o'clock.
I know it's the 21st.
What, I know it's a Wednesday. Is it the 21st?
I got it.
Hold on. Yeah, May 21st, you're right. So
What happened-
typically you may get, it might be, if it was one question, it would have everything in it. One family with all the problems, delinquents and chins kids and, you know, the role of counsel, sexual abuse, or it might be, you know, 3 smaller questions that are more distinct with, you know, one child or a few children, so it depends. And again, as I said, the call of the question, sometimes you're advising someone, sometimes you're arguing for a side, sometimes you're more objective in terms of the judge deciding the case. Any questions? All
I
right,
just
so.
have a quick question, actually, it just has to do with the exam. I haven't even started to look at them yet, but are the prior exams that
Oh,
are
yeah.
online, are
Oh,
they
yeah.
like relatively close to the format that you're gonna use?
Yes.
'Cause some
Yes.
professors, it's like completely opposite of what
No,
they use now.
no, but it's
Others,
always a new
you know,
crazy story.
No, but, you know, the same general
Yes.
idea.
The
Okay.
general idea in terms of the call of the question,
Yeah.
different facts. So we'll do, hopefully, I think we'll be able to do Sissy all on Thursday. If we don't, we'll just continue it to the following Tuesday.